All rise. We will obey. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please call the case.
Merci, Monsieur le Président. La situation en République du Kenya dans l'affaire le procureur contre William Samoei Ruto et Joshua Arap Song. ICC 0109-0111. Nous sommes en audience publique.
Thank you. Appearances.
Good morning, Mr. President, Your Honours. For the prosecution this morning, Anton Steinberg, with me Lara Renton, Alice Zago, Regina Weiss, and Grace Go, case manager.
Good morning, Mr. President, Your Honours. The victims participating in this case today are represented by myself, Arslan Arenstik, and my colleague, James Mayweather. Thank you.
Good morning, Your Honours. For Mr. Sang, who is present, is Rong Sin, Lorna Lanham, Logan Hambrick, Caroline Buisman, and myself, Katwa Keegan.
Good morning, Mr. President, Your Honours. On behalf of Mr. Ruto, who is excused, myself, Kareem Khan, Shamala Alagendra, Miss Lee Laurie, Miss Grace Sullivan, and Miss Shalini Jairaj.
Prosecution, your next witness.
Yes, good morning, Your Honours. We are in public session, but that's not a problem because the next witness has not requested any protective measures, nor has the VW requested any protective measures. So I can say that the next witness, Mr. Gavin McFadgen, I beg your pardon, is available to be called. Perhaps before he's called, there is one matter that my learned friend, Mr. Keegan Katwa, raised on Tuesday, relating to the procedure which the prosecution intended or suggested be adopted with this witness as regards the admissibility of documents. There are a number of documents the prosecution would like to show to this witness, including the CPEL final reports, but also some underlying material. Apart from, I think, 6 or 7 underlying documents, the rest of the material is in dispute. And I do anticipate that there would be a fairly lengthy and possibly complicated legal debate about this. Your Honours have been informed that the witness has health issues, and my suggestion, Your Honours, was that in the interest of shortening his evidence, that the relevant documents be shown to him, identified, any questions which the prosecution deems fit be put to him on that, but that the issue of the admissibility of these documents be debated subsequently by way of written filings. That way, in my submission, we could dispose of this witness much more efficiently than if he had to sit through all of the legal arguments. Both my learned friends have agreed to this proposed way of proceeding, but obviously we're in the hands of the court in that regard.
Mr. Keegan Katwa.
Mr. President, in respect to the issue of the documents that are in dispute being determined by way of an application, that is our position, that we prefer filing in respect to that issue.
Mr. President, my learned friend Mr. Steinberg has accurately put forward the position. We are content with that arrangement. There is another matter that I would like to raise with the bench before the witness is brought in, but on that issue, we agree with the prosecution.
All right, before you raise the matter, Mr. Steinberg, assuming we proceed according to the joint recommendation of counsel, as you've laid it out, how long do you anticipate this witness's testimony would take?
Your Honours, my estimation is approximately 3 sessions, so depending on how long the preliminary issue my learned friend wishes to raise would take, I'm hopeful we might be able to finish by the end of the day, at the latest the first session tomorrow.
And you mean examination in chief only, or including, in your estimation, cross-examination?
Your Honours, I've had no confirmation of the length of cross-examinations. I'm referring only to evidence in chief.
Defense, are you able to, at this point, indicate how much time you think you might take in cross-examination?
Your Honour, at the moment, and I've consulted with my learned friend, our hope is that we'd finish cross-examination within 2 days. Hopefully, maybe even one.
You mean you will need 2 days?
Indeed. We hope, in fact, one, but I don't want to be curtailed, so I hope one, but definitely we'll finish on behalf of both of us within 2. But, Your Honour, the issue, if I can raise it now, is our application is that we should not be required to start cross-examination before Monday. If Your Honours give us leave to start on Monday, we'll undertake to finish either by the end of Monday, but at the latest on Tuesday. And the reason for that is we have been, we say, significantly prejudiced by the way that the prosecution has handled this matter. Your Honours, we received yesterday a proofing note, and I won't say too much about it. Whether it's a proofing note or a new statement is another matter. Certainly for the first time, new matters are raised, for example, a reference to USAID, a reference to Mungiki's relationship to ODM, and of course that issue is subject to another filing. Your Honour, the witness also, for the first time, is asked questions about the process of WACI in the sense of witnesses' testimony being tested. And he says that as a police officer with many years' experience in questioning witnesses, he considers he has a reasonable nose for someone telling a yarn, and is not often wrong in his assessment of witnesses. And, Your Honours, after that, the prosecution, for the first time, because it's not done when the statement's taken, go through transcripts of evidence, not just WACI, the report that we thought he was going to speak about, but critical underlying evidence, and he purports to give credibility assessments in relation to that material. Now, Your Honours, we got a list of, we raised it before we broke from the last session, but we received on Friday, I believe, a list from the prosecution regarding portions that they would seek to tender through this witness. And we received yesterday for the first time the proofing note in which the witness is taken through certain documents that were not put to him at the time the statement was taken. Your Honours, these are important matters. They raise legal issues. They also raise issues of preparation for the defence. And so we understand, my learned friend has said, that there may be some health concerns of the witness, that the proceedings may need breaks anyway. And what we're saying, and I can go in much more detail if necessary, but the number of it is we're saying that we'd ask, whenever the prosecution finish, on behalf of my learned friend and myself, it's a joint application, we'd be allowed to start only on Monday so we can consider some of these transcripts and our approach to them, because he does purport in this proofing note not only to speak to specific transcripts and underlying material, but he purports to make credibility assessments. For example, certain individuals appeared credible and the like. Your Honour, also in light of that, I sent an email, or Ms. Allegendra sent an email yesterday to the prosecution seeking further disclosure regarding 2 people named in the witness statement. And we've asked the prosecution whether or not those people have been interviewed by the prosecution at any stage, and whether or not the prosecution has any information that those individuals who appeared at WACI are telling untruths. So it's relevant to this new statement because the witness says he has a nose for credibility. It's individuals that are mentioned in his statement, and the defence wants to know if the prosecution also are saying now.
But Mr. Ken, are you bound by any particular witness's ability to smell credibility? Or, more importantly, is the court bound by it?
Your Honour, the court, of course, not only is not bound by it, we say evidence should not be led on it. But, Your Honour, because this goes beyond the scope of the original statement, because the statement, and if one looks even at the summary that the prosecution gave when they were seeking to call this witness, when the trial started,
Right, let's do this. Your arguments are in support of your request that you not be compelled to start cross-examination earlier than Monday.
yes, Your Honour, and if we do, we undertake we'll be finished either by the end of Monday, but definitely by Tuesday.
But in spite of the matters you have identified as problematic for you, there surely must be other areas that you can cross-examine upon earlier than Monday.
Well, Your Honour, what we don't want to do, and that's the issue, one wants to view the landscape of cross-examination at the outset and know exactly what the defence approach is going to be. Now, we are hampered due to no fault of our own because the original statement really was formalistic. WACI was established, these were the general processes, and here is the report. That was the clear ambit of the original statement. At proofing, here in The Hague for the first time, new documents are shown to the witness for the first time that were not shown to the witness in the 2 previous interviews they had with the witness. That's point number 1. And the second point is the underlying documents go well beyond the WACI report, but the underlying material upon which WACI was based. Now, Your Honours, we say we are, with respect, entitled to adequate time to prepare in light of that. It's not the fault of the Chamber, it's not the fault of the defence. The prosecution have chosen to conduct themselves in this matter. I'm not even at this moment aiming my fire at the proofing because some of these issues, Your Honour's decision does allow the prosecution to go into matters of possible defence cross-examination.
The concern here is this.
Yes.
The concern is, let's assume that this happens in many trials, so witnesses understand and they start expanding their story beyond what might have been said in a 2 or 3 page statement. And often in criminal cases, statements are not long. Witnesses will take hours testifying. They would not be just testifying precisely out of a script of 2 pages. And if in the process of testifying, expansions are made to narratives that are substantive in themselves, you can see the difficulty it will cause if every time that happens, cross-examiner will say, court, you have to adjourn until we're ready to cross-examine on these things. There's certainly something can be done, and if there's any prejudice raised, will have to be argued or taken into account at the time, at the right time.
Your Honour, of course, I agree with that. It's one matter, though, for an issue to arise ex improviso, unanticipated in the course of examination. But this is an issue of fair notice to the defence. What's the purpose of a statement? The statement is there to give the defence a target as to the scope of examination. That's the purpose of it, otherwise it has no purpose at all. But here, despite 2 interviews, for the first time, the witness is taken through documents that the prosecution are now seeking to tender for the first time, which include transcript evidence, and I leave Rule 68 aside for the time being. And the defence is given the witness's comments yesterday. And so all I'm saying, Your Honours, is that this is not a matter where it's 1 or 2 small issues. It appears that the thrust or the focus of the questioning has, if not changed, it's expanded quite significantly. And in the scheme of matters, the court schedule, of course, is there until the 16th. We say we're trying to accommodate the prosecution. We've said, in light of the witness's condition, we can argue admissibility by way of written motion. All we're asking, we think, is a very modest request, is that consideration be given on behalf of Mr. Katwa-Keegan and myself, that the defence should be entitled to have the weekend to go over material that arises out of information given for the first time yesterday.
All right, let's leave it there. Mr. King Katwa, Mr. Khan said he spoke on behalf of the both of you. So you don't need to speak more on this, do you?
It is true he spoke on behalf of both of us. Mr. President, may I mention that apart from the postulation that some of the issues in the proving notes are new, there are instances when the witness has actually said the opposite of what he had said initially in the screening notes and in the subsequent statement. And that, Mr. President and Your Honors, we pray should entitle us to more opportunity to look at what is introduced by the prosecution.
Mr. Steinberg?
Thank you, Your Honor. I must confess to being somewhat perplexed by my learned friend's complaint, particularly the complaint that he's taken by surprise that not only the CPEV report but certain underlying documents were put to this witness for his comment. I note that it is not just the CPEV report, but every single item that was put to this witness was disclosed on the prosecution's list of evidence on the 5th of May 2011, clearly indicating this was material upon which the prosecution intended to rely. This witness, Mr. McFadden, and the previous witness, witness 247, are the two witnesses on the prosecution's witness list from the CPEV Commission, and I would have thought it quite obvious the witnesses through whom the prosecution would seek to tender this evidence. In addition, certain underlying material has also been sought to be submitted via bar table motion. And I note, for instance, that certain of the transcripts we now seek to tender through this witness, including the testimony of one Professor Harun Ngeni, Dr. Stephen Kaya, and Dr. Shadrach Kamei, when we sought to tender this evidence through the bar table motion, the defense for Mr. Ruto did not object. Their response was, agrees to the admission of the portions of the document identified by the prosecution, subject to certain reservations. I beg your pardon, this was the agreed facts filing. I'll give the reference. It's ICC 0109 0111 1121, confidential Annex A. And it's item number 45 under the heading non-ICC transcripts. As Your Honours is aware, the protocol for witness proofing permits the prosecution to put documents to a witness upon which the witness, or the prosecution might seek to put to that witness for comment and possible admission, amongst other reasons, to determine the utility of using those documents with the witness. Now, given that the prosecution seeks to tender the CPEV report as an exhibit in this case.
But you see, they're not objecting necessarily to tendering the documents or you reviewing those documents with a witness. That's not my understanding of their position. Their position is that that may not be required to start cross-examination earlier than Monday. What do you say to that?
I understand the position, Your Honours, and the basis for the submission is that they've been taken by surprise. And my submission is that they should not have been taken by surprise. They should come as no surprise to them. Your Honours, I leave this matter in the court's hands, but the prosecution's point of view is that we're dealing with a witness who's not in the best of health. He should not be kept here longer than necessary. And with the exercise of due diligence, my learned friends could have and should have done the necessary preparations in order to commence cross-examination promptly. The two matters that they raise regarding questions put to him as to US aid and as to the involvement in Mungiki are simply matters that arise out of questions and lines of cross-examination that have been put to previous witnesses that the prosecution thought this witness might be able to comment on.
All right. Mr. Keegan-Cartwell, so your undertaking is that if you are allowed to start only on Monday, you will complete on Monday.
Sorry, Your Honours, we'll do our very best to finish the end of Monday, at the very most, the first session on Tuesday, but we'll do our very best to finish at the end of Monday. If the court is minded to grant the request, the least we can do, of course, is try our utmost to comply with any orders of the court. I'll say no more.
Mr. Khan, Mr. Keegan-Katwa, we will start this witness's examination in chief. We will consider the matter again at the point of the prosecution's completion of their examination in chief. We'll revisit the matter at that time. It may well be that there are some questions you could put to the witness in the meantime. It may well be that your concerns or the prejudice you worry about might become clearer at that stage, at the stage of the completion of the examination in chief, rather. So the point being, be prepared to start, but we will think about it.
I'm grateful. Your Honour, one additional matter, of course, is I won't repeat the submissions, but we received the proofing note yesterday. There is a rule, of course, that any material we wish to put, we must give the prosecution 24-hour notice. So if I gave it on that material tomorrow morning, of course, I could use it on Monday. But as of the moment, I haven't got that material, I'll confess. I'm not ready for it because this is unanticipated. And I will not be able to put certain material that I think we're entitled to. In fact, I'm not even sure what material I'm going to put. I have a broad idea, but selections have not been made. So, Your Honour, it's another factor I would ask to be considered. I'm grateful.
We'll keep that in mind as well, because if the prosecution takes an issue with that, then it may well be at that point that you'll need to make that argument.
So, Your Honour, will we get a decision from the bench today on that issue, or will it be only as to when we are expected to start?
We're not going to give you advanced ruling on it now.
But later?
Yes.
I'm grateful.
Let's bring in the witness. Mr. Steinberg, you're going to take the witness?
I am, Your Honour.
Did you give the advisories under Rule 66, 3 and 74, 1?
I confirm that I have, Your Honour.
Yes. I thought I should have. There's an announcement. Mr. Keegan-Katwa, we will be adjourning today at 3:45. I mentioned you, Mr. Keegan-Katwa, just to draw your attention, not that this is an announcement particular to you. I noticed you were engaged in a discussion at the time. We will be adjourning at 3:45 today, so everybody knows that. Please administer the oath to the witness.
I solemnly declare that I will speak the truth, the whole truth, and nothing but the truth.
Thank you very much, and witness, welcome to the court, to the ICC.
Thank you.
And when I welcome witnesses, I don't want them to feel like strangers to the courtroom, because this is your courtroom. It is international. It belongs to the international community of which you're a member. We thank you for joining us in our search for the truth in the case before us. And in that search, as you probably know, we do it by questions and answers. The counsel in the case will be asking you questions, beginning with the party that called you. the prosecutor would ask you questions in examination in chief. After that, the defense counsel for Mr. Ruto or Mr. Sang, they would take turns asking you questions. At the end of all that, it may well be that the victim's counsel represented over there would also may need to ask you questions if they request to do so, and we grant them leave to do so. In all of that, questions. I suspect that you're familiar with the process. In answering those questions, it is critical that you concentrate on the precise question asked and give only the answer to that question in as concise a manner as possible, and then stop and wait for the next question. It is often the case because of how we operate, and I will be speaking to you in a moment about that. There's something we call the pause rule. Again, I'll be speaking to you about that. We're required to take pauses in between question and answer. Sometimes when that pause is occurring because the prosecutor is pausing, observing his own pause, some witnesses might then think that they haven't given enough for an answer, and they'll keep talking. And so that's why I say, think about the answer that is called for by the question, give it, and then stop. There'll be a pause from the prosecutor or the questioner, and then they'll ask you the next question. Keep that in mind. Please do your best to eliminate guesswork and speculation. If you must draw inferences, so be it. But to some people, what is an inference to somebody might be speculation to another person. So keep that in mind. Do your best to give us informed answer that you thought about as opposed to speculating or guessing. We're interested more so in what you have observed directly or your own perceptions than hearsay testimony. But in the manner of your testimony, it may well be that you may have to base yourself on information you received from some other sources. Let's try and keep that to the minimum, if that must be right. We've been informed that you may require, from time to time, breaks. If you do, let me know. Okay? Right. Now, the logistical matters. There are people who assist with a team here. There are also part of the team are up in the compartment. You see there, the interpreters are up there, and the court reporters are also up there. They cannot hear you directly except through the microphone and through their own headsets. So for that reason, it is important at all times that we do not have overlapping speakers, hence the pause rule that I indicated earlier. The testimonies are interpreted into French, and it is often the case that when the speaker finishes speaking in English, the French interpreter is finishing interpretation. So if one starts speaking immediately, it may cause problems of interpretation. It is for that reason that we observe the 5 seconds pause. Try and do that. The prosecutor will do the same thing. Thank you very much for coming. Mr. Steinberg.
Thank you, Your Honours. Good morning, sir.
Good morning.
Please state your full names for the record.
My name is Gavin Alistair McFadyen.
And before we get into the meat of your testimony, Mr. McFadyen, I'd just like to go through some details of your work and experience in the past. Is it correct, sir, that you were a police officer in New Zealand for 32 years? of which 16 years was spent in the field of criminal investigations.
That is true.
And what rank did you rise to within the New Zealand Police Force?
Assistant Commissioner of Police.
Responsible for what area?
Responsible for operations.
Is it also correct, sir, that in 2004 you participated in a panel appointed to review certain disputed elections in Papua New Guinea?
Yes, that's right.
And subsequent to that, you became the head of security for the New Zealand Rugby Union, correct?
I worked with the New Zealand Rugby Union on a range of security matters.
And finally, is it correct that in 2008 you were invited to participate in the Kenyan Commission of Inquiry into the Post-Election Violence, or CPEV, as one of the 3 commissioners?
Yes, I was.
And do you currently hold any position, work-wise?
I work on my own account, providing consultative services across a range of sectors.
Thank you, sir. Can you please tell the Chamber how you came to be appointed as a commissioner at the CPEV Commission?
I received a communication from, I think it was a UN group supporting the panel of eminent African personalities, asking if I was available. I believe that was late March 2008. I was available and interested, and subsequently I was appointed as a commissioner.
I'm grateful. Your Honour, before we go on, I wonder if my learned friend could be kind enough, because it's not in the statement. For the first time we've heard that the witness is providing consultative services over a range of sectors, and it'd be very helpful to have some idea what that means. So I'd ask, just in the interest of fairness, because it's not in the statement, we don't know what it is, if a couple of questions could be asked so we can be put in the picture early on. I'm grateful.
Your Honours, that's not a matter which is relevant to my questioning, and obviously it's a matter which my learned friend could question the witness on if it does interest him. But on this instance, I have no objection to putting the question. So you've heard the inquiry of my learned friend. I wonder if you could give some more details as to your current work, if you're able to.
Range of sectors in particular.
Okay, one of the sectors is major events, mainly sporting events. And from time to time, I've been asked by senior people in mainly government organisations to assist them with any support they might need. For example, if this helps, the New Zealand Police asked me to look at their complaint system and some work they were doing there.
I'm grateful.
Would this be complaints by members of the public about actions of police?
Yes, that's right.
Very well. I'd like to show you certain documents that are not, I believe, in dispute relating to your appointment and the establishment of the CPEV Commission. And if I could ask you to look at the binders in front of you. The first binder, on the spine it's marked folder 1. And if you could turn, please, to tab number 3 of that folder.
Monsieur Steinberg, pourriez-vous indiquer le numéro ERN du document, s'il vous plaît?
Certainly. The ERN number is KenOTP 00030406. My apologies. Sir, do you recognize that document?
Yes, I do.
And is it correct that that is the Gazette of the law establishing the CPEV Commission?
Yes, it is.
And one sees your name there on the left, about halfway down as one of the 3 commissioners. I will return shortly with some questions about the other staff members on this page. Can you confirm that part of your mandate was to issue a report at the end of the process?
Yes, it was.
And did you do so?
Yes, we did.
Did you, sir, contribute to the writing of that report?
Yes, I did.
And as one of the commissioners, did you yourself sign off on that report before it was submitted to the Kenyan government?
Yes, I did.
Thank you. I'll return in due course to that report. Can you please flip over to tab number 4? Your Honours, there are a series of documents. I note that from prior practice, the preference of the court is to deal with them one by one.
Yes, if you intend to tender this, this is the time to do so.
I asked for this document to be admitted as the next in the series of the prosecution exhibits. My understanding is that this is agreed by the defence.
It is. I'm grateful.
It is, Your Honor.
The document is admitted as the next in the prosecution exhibits.
Le document KEN OTP 00030406 public se verra attribuer la cote EVD T OTP 00121 ou pièce de l'accusation numéro 121.
Thank you.
In fact, yes, let's proceed then to the next document. Can you please look at tab 4, document number KenOTP 00410770, and tell the court if you recognize that document and what it is.
Yes, I do. It's a little blurred, actually, but it was our Commission's published rules and procedures.
And who drew up these rules and procedures?
Commissioners drew up these rules and procedures.
Your Honour, I ask that this be admitted as the next in the series of exhibits. I understand also no objection from the defence.
Do you not have a better, more legible version of this document?
Yeah, because, Your Honour, we did say there was no objection, but we also did make the same point. This copy is not legible.
Your Honours, I don't have one to hand. I dare say that this being a public document, the prosecution could get hold of one.
All right. There is no objection, Mr. King, from Mr. Ruto. Mr. King, are you?
None, Your Honor.
Right. The document is admitted as the next in the prosecution exhibit, and Mr. Steinberg would make efforts to obtain a more legible version.
And turn then, please, to tab number 5.
Excusez-moi. Le document KEN-OTP 0041 0770 public se verra attribuer la cote EVD T OTP 00122 ou pièce de l'accusation numéro 122.
Thank you. Mr. Witness, the next document at tab 5, KenOTP 00410771. What is this document, sir?
This document publishes an extension of term for the completion of the work of our commission.
And at whose request was this extension granted?
The commission requested the extension.
And in this regard, could I please ask you to turn to tab number 7, document KenOTP 00030414. Can you identify that document?
Yes, this is a document that was written to support the request for an extension of time.
Just one matter of clarification of this document. If you could turn to the last page, please. The reference is KenOTP 00030418. Specifically, the last paragraph. The first line reads, "It is our view, therefore, that the Commission requires a further," and then there's a space, followed by the words "months" to complete its work. In manuscript above the space is written what appears to be 22 space 00. Can you clarify what that's about?
No, I don't know what the 2200 relates to. The request was for 60 days extension.
Thank you. And it seems from the document at tab 5 that you were in fact granted 30 days at this point.
Yes, that's correct.
Thank you, Your Honours. These two documents are related. I ask that they both be admitted as exhibits. That's 00410771 and 00030414. I understand there's no objection to these documents going in.
One at a time, one at a time. So the 0041
0771, Your Honours.
Yes.
Apologise for the tiny font size.
Yes, being the extension of term. We deal with that first. So, any objection?
None, Your Honor.
Okay. The document is submitted as the next in the prosecution exhibit.
Monsieur Steinberg, pourriez-vous confirmer le niveau de confidentialité de ce document, s'il vous plaît?
The document is public.
Merci. Le document KEN-OTP 0041 0771 se verra attribuer la cote EVD T OTP 00123 ou pièce de l'accusation numéro 123.
And now we come to the next document, which is 0003-0414. Is that it?
Correct, Your Honour. Once again, I believe there's no objection.
Any objection?
None, Your Honor.
Mr. Khan says no objection. the documents submitted then as annexed in the prosecution exhibits.
Monsieur Steinberg, encore une fois, s'il vous plaît, niveau de confidentialité.
Again, public.
Merci. Le document KEN OTP 0003 0414 se verra attribuer la cote EVD T OTP 00124 ou pièce de l'accusation numéro 124.
Mr. Steinberg, on this document, are you going to ask any questions about the significance of the handwritten 2200 at page 418?
Your Honour, the witness has said that he doesn't know what those figures are, but that the request was for 60 days or 2 months.
So you are admitting the document for everything else except the handwritten information, is that it?
Perhaps I can just clarify that with the witness. So, besides the issue of the manuscript numbers appearing on the last page, do you confirm that this document represents the motivation you provided for the extension of your term?
Yes, I can.
So in other words, this would be more or less a facsimile form of the request for extension of time, except for the written information in there.
Yes, Your Honour.
Thank you. So, before I show any more documents to you, can you please tell the court, to the extent of your knowledge, what was the background to the appointment of this commission, the CPF commission?
Well, as far as I'm aware, the genesis of the commission was in an agreement between the parties in Kenya and the panel to establish this commission, along with other commissions, and that was agreed to, I believe it was early March 2008.
And can you just clarify for the record, please, what you're referring to by the parties and the panel?
Well, the parties were representative of the two political parties, if you like, in Kenya. And the panel is the panel of eminent African personalities who worked with the parties.
When you refer to the two parties, I don't think that there's any dispute that these would be the PNU and the ODM respectively, correct?
Yes, that's right, and representatives from each group signed off on the agreed way forward, if you like.
And did you ever have sight of this agreement?
Yes, I did see it.
I wonder if you could please then turn to tab 8 of your bundle. I refer to document KenOTP 00030390, which I believe is a public document. Can you identify that document?
Yes, it's the document I was speaking about, creating, among other things, our commission of inquiry.
And in fact, if one looks through the document, there's reference on the first page to your Commission of Inquiry, CPEV, but there's also reference to certain other institutions such as the Kenyan National Dialogue and Reconciliation, Truth, Justice and Reconciliation Commissions, and Independent Review Commission. Correct?
Yes, that's right.
And turning please to, the pages aren't numbered, but the ERN number is KenOTP 00030398. It's the 5th sheet of that document, where there stands a list of names and spaces for signatures, headed signed on this day, 4th of March 2008. Do you have that?
Yes, that's right.
Are you able to confirm that these were the signatories to the agreement?
Yes, that's correct.
Now, the prosecution only has this unsigned version in its possession. Did you at any stage see the signed version of this, or can you tell the court where it was?
Yes, well, I did see a signed version, but I can't just remember exactly where that was. But I certainly did see a signed version, yes.
Thank you, sir. Your Honours, the prosecution would then ask that this document also be admitted as the next in the series of exhibits, 0003 0390. It's a public document. As I check my list, it seems that this is also not disputed.
Any objection?
Your Honor, I do object. These are under one tab, but they're different documents. And the witness has not been asked if the documents are complete, because it seems clear to us they're not complete. So Your Honor should be wary to admit documents that are incomplete, not just because of the absence of the signature on 0398, but Your Honor, the rest of it also is incomplete. So questions should be laid, asking the witness, is this the complete entirety of both of both documents, the Commission of Inquiry on Post-Election Violence, that purports to finish on page 2, which is ERN 0391. Is there not another page or pages after 0391? And then the completely different document with new pagination, which starts at 0392. So, Your Honour, unless that is clarified, there is an objection.
Mr. Steinberg?
Your Honours, well, firstly, may I just confirm that the portions that the prosecution is interested in is simply the first 2 pages and the signature page. The rest was put in for completeness as this came to the prosecution as a single document. But I will put the questions to the witness and see whether he can elucidate. Sir, are you able to shed any light on my learned friend's query as to the completeness of these documents?
Well, no, I can't. As I've said, I have seen these documents, but in terms of the how they're put together exactly, I can't say any more about that.
Mrs. Steinberg, you might want to help the witness more. If you look, what Mr. Khan is saying is that these appear to be a bundling up of several documents. So if that is the case, it seems to me you might want to unbundle them through questioning or any other manner.
Yes.
Treat the documents one at a time, and then see whether you need, at the end of it, to add them all up together again by way of submission or something.
Yes, I will attempt to do so, Your Honours. As I've stated, for present purposes, I'm really only interested in the first document and the signature page. But let's start one by one.
Your Honour, can I
The
help?
signature
So-
page to what? Mr. Khan, yes?
Your Honour, just to help, perhaps to help my friend, perhaps the witness can simply be asked in relation to the two documents, the one finishing 0391. Was it the case, in fact, that had a separate signature page as part of that document, and then the second document, which ends 0398, is a separate signature page for a separate document? So in the end, these were not signed one signature page for one document. There were two separate documents with two separate signature pages. That may help.
Mrs. Steinberg, do you have difficulty accepting that suggestion?
Not at all, Your Honours.
Okay. Why don't you proceed on that?
Thank you. So please look then at the first two pages entitled Commission of Inquiry on Post-Election Violence, and then numbered pages 1 and 2. Do you know whether there were any other pages to this document, including a signature page?
Well, no, my recollection is that there was no signature page purporting, just relating to that 2 pages. It's my recollection.
And the next document, headed Kenya National Dialogue and Reconciliation at ERN 0392. Were there any further documents or pages, as far as your recollection goes, under that heading?
Well, I have no recollection of any further pages.
Turning over to the following document at 0393 and 0394, headed Truth, Justice and Reconciliation Commission, I note that the second page ends halfway down the page. Were there any further pages of that document that you're aware of?
Well, I don't recall.
And finally, the document headed Independent Review Committee at 0395 to 0397. Again, seems to end halfway down a page. Were you aware that if there were any further pages to that document?
No, I'm not aware.
According to your recollection of seeing these documents at the time, can you recall whether each of these documents, or what was transmitted to you, had separate signature pages or only one signature page?
I only recall one signature page for a group of documents.
Court will bear with me, please. Your Honours, as I've said, these are handed in together as they were received as one document. The prosecution does not intend to rely on the pages from 0399 to the end of the document at 0405, which are essentially irrelevant for our purposes. Of course, the defence are welcome to ask any questions on that. So with that further clarification, then the prosecution asks for the admission of this document from the ERN range 0003 0390 to 0398, the signature page.
Any objection?
Your Honour, no objection, with the caveat we've mentioned about whether it's one document or several different documents, and about missing pages.
No objection on our part.
The document is submitted then as, the bundle of documents submitted as the next in the prosecution exhibits. That would be the documents appearing from 0390 to 0398.
Le document KenOTP 0003 0390 jusqu'à la page 0398 se verra attribuer la cote EVD T OTP 00125 ou pièce de l'accusation numéro 125. Le document est public.
Thank you, Your Honours. So I'd now like to just ask one or two questions about the mandate of the CPEF Commission. Subsequently, I'll be dealing with issues relating to the functioning of the Commission. What was your mandate, sir?
Well, our mandate was clearly set out in the Gazette reference, articulating what we were expected to do and how we were expected to do it.
You referred to the Gazette at ERN 0406, tab 3, correct?
Yes.
And was there any time limit on the execution of this mandate?
Yes, there was. There was a time limit, if I can find it here. It was to be finished or completed within 3 months, from memory, and with the possibility of another month.
And I'll come back to that and to the your request for an extension. Now, the persons mentioned in that same document, the commissioners, are named as Judge of Appeal Philip Waki, yourself, and one Pascal K. Kambale. How are these persons selected, do you know, to be commissioners of this CPEF Commission?
Well, I don't know specifically why it was that they were selected, other than a similar process to my own, I guess.
You've referred a moment ago to the agreement, signed agreement, which is at tab 8. Are you aware whether any agreement was reached in relation to the senior officials of the Commission?
Well, there was an indication in that document under the heading Composition about how the Commission of Inquiry or who would compose or comprise the Commission of Inquiry.
You're referring
which
to
document now?
Your Honours, I can refer Your Honours, it's ERN 0391, which is the second page of the document at tab 8. It's in the middle of the page. Perhaps I can just read that into the record. The Commission of Inquiry will be composed of 3 impartial, experienced and internationally respected jurists or experts in addressing communal conflict or ethnic violence. 2 of these shall be international and 1 shall be Kenyan. They shall be selected by the panel following consultation with the government/PNU and the ODM and appointed by the President. Is that your understanding of the selection process?
Yes, it is.
I note at the bottom of the previous page there's also a paragraph headed National Cooperation, which specifies that the Kenyan authorities shall give full cooperation to the Commission, including access to various records. Did you receive such cooperation?
Yes, we received a lot of cooperation from the government of Kenya and from various Kenyan authorities and entities.
Returning then to the issue of the time granted to you of 3 months, what can you tell the court about the sufficiency of this time to complete your mandate?
Well, frankly, the time frame was going to be obviously difficult. We recognised that before we started. One of the reasons for that was that this commission, or at least the commissioners and the 5 appointed office bearers, if you like, the 3 commissioners, counsel assisting and the secretary, we needed collectively to create our own set of arrangements, including how we were to operate, hence the rules, where we were to operate, getting staff on board, all of those, administrative elements that take time, frankly.
And you've already told us that you were granted an extension of 30 days. You asked for an extension of 60 days and were granted an extension of 30 days. Were any further extensions granted?
Yes, it was. We sought a further extension to assist in the time to write the report at the conclusion of our investigations.
And how much time were you granted?
We were granted 2 weeks.
And if I can complete this series of documents, if you can turn to tab 6 of the bundle, ERN 00410772. And is it correct that that represents the 2-week extension of time to write the report?
Yes, it is.
Given these extensions, can you comment on...
Before the question, is this document already on the record?
I beg your pardon, no, I omitted that. I asked that this document be admitted as the next in the series of exhibits. It's a public document. I understand there's no objection.
No objection.
None.
The document is admitted as the next in the prosecution exhibits. And again, this time back, look for a more legible copy.
Will do so, Your Honor.
Le document KenOTP 00410772 se verra attribuer la cote EVD T OTP 00126 ou pièce de l'accusation numéro 126. Le document est public.
Thank you, Your Honors. I'd like to then deal a little bit more detail with the staffing of the commission. Philip Waki is indicated as being a judge of appeal. He was Kenyan, is that correct?
Yes, that's correct.
And can you tell us, please, who was Mr. Pascal K. Kambale and where he came from?
Pascal Kambale was from the Democratic Republic of Congo. He has a law degree, and from my understanding, had been working amongst other places, I guess, in the USA.
In what field?
My understanding is human rights field.
Besides the Commissioner, the other two persons appointed by the President was one George Mongare Kegoro, appointed as the Secretary. Can you tell us about who this person was and what his duties were?
Yes, Mr. Kagoro is Kenyan. Also I think the term is an advocate of the High Court of Kenya. Well, the only other thing, I guess, is that he was appointed as secretary, a role he'd had before, actually, with other commissions of inquiry, or at least one.
And what was the role of the Secretary in the Commission?
Well, his role, by and large, was provide or oversee all of the support to the commission and the commissioners, administrative proceedings, support with our hearings and those sorts of things. Also, documentation and the security of it, and those things.
And the last member appointed by the President was one David Shikomera Manjanja. What can you tell the Chamber about his background and role?
Mr. Manjanja was also an advocate of the High Court of Kenya. He was appointed by the government as counsel assisting the Commission. And the role, I guess, of the counsel assisting is to do just that. For example, he would oversee witnesses to be heard by the commissioners. He had a teams working with him, a legal team, for example, and also a team of investigators.
And according to your understanding, were these two additional people also appointed by agreement between the various parties?
Well, I'm not sure that those positions were specified by the agreement parties or not. I'd have to have a look at the document.
Did counsel to the Commission also participate actively during the proceedings in questioning witnesses?
Yes, that's right, Your Honour.
I will, Your Honour, be returning to the issue of the actual hearings and the manner they were conducted in due course. Now, I note that in the agreement it specified that as far as methodology is concerned, I'm referring again to ERN 0391 at tab 8. It specified that the Commission of Inquiry shall develop its own work plan and procedures. These will be guided in all respects by principles of fairness, impartiality, transparency, and good faith. Can you please tell the Court, sir, how you went about developing the methodology for this Commission?
Well, once the three commissioners, counsel assisting and the secretary were sworn in, early June, I believe, 2008, we worked together to determine just these points, how we would work, what our plan would be, our approach, I guess, and the procedures that we needed to put together to make it all work. So during that period, from being sworn in until the first hearings were held. Much of that early time was devoted just to this area.
And what methodology did you develop as far as publicity of the proceedings were concerned and issues of media liaison?
Well, we resolved at a very early stage that that where possible, proceedings would be held in public. And to that extent, we promulgated procedures around those arrangements, and we informed Kenyans about this at an early stage, publicly. But in addition to that, we also determined that where we needed to, some witnesses may well need to be heard in camera.
How important was the issue of publicity to your work in the view of the commissioners?
We felt that was very important. This was an important decision that the parties had made to create the commission in the first place, and we felt it critical actually to hold as much of our work in an open way as we could. So, of course, many of the proceedings were just that. Members of the public were advised when hearings would take place, invited to attend. All of the open hearings were reported extensively by media, both on television, live in some cases, as well as reported in the press and on the radio.
How important was the issue of impartiality considered by the commissioners?
Well, impartiality is a fundamental aspect of our commission. It should be of any commission, actually. So aspects around fairness and openness we discussed at an early stage, and how we might ensure that impartiality and even-handedness, I would say.
And how did you go about that?
Well, of course, at the beginning, the five of us swore an oath, as I say, in early June, to discharge our duties in that way. And it was pretty clear to us that that was important. But, of course, we employed a number of people to work with us. And it was made clear to each and every one of them how important the Commission was to Kenya, how important their behaviour was when they worked with us, and to respect confidentiality and our even-handed approach to our work. And in fact, we created an oath that was administered by Judge Waki to every individual who worked with us.
Thank you, sir. And
Mr. Steinberg, can we leave it for now?
this would be an appropriate time, Your Honour.
Yes. We will take our morning break now. We'll come back in 30 minutes. The court will rise.
All rise. We will wait.